Buckle up, kids. You're exiting the ordinary and entering the court gallery. That was almost a mistake. Ooh. Caught it, though. Hi. Hi, guys. You ever have one of those moments where you feel like you're fully prepared and then you start getting like right in the middle of the thing that you had planned to do and realize you're far less prepared than you thought you were? Yeah. Welcome to the court gallery, ladies and gentlemen. I am your humble host, Lone Wolf Usul, and I bring to you a compilation of crazy cases from today. And a little bit of one from yesterday that we started yesterday. You know, it's that McNally case. We're going to start with Judge Johnson because Judge Johnson had a couple of pretty decent cases. The first case she deals with, well, I'm not giving either of them away. There's a lot of information in the description about all the cases. If you're interested in time codes and the case information, check out the descriptions. I'm just going to let you know Judge Johnson brings out the judge mom that we see come out a lot. Judge McNally is dealing with that case of fraud, paying for the car thing, but there's also some side quest we have to take in the middle of all that, so buckle up. McNally's interesting. The Hayward case from Georgia, that's a dog bite case. I do want to issue a little bit of viewer discretion warning. We're going to look at some evidence. It is actual dog bite from the victim, dog bite evidence from the victim. Just prepare yourself. It all starts right now.
To A, and that is people of the city of Southfield versus Purvis Brothers. And then we have case number 22S00177SM, people state of Michigan versus Purvis Brothers.
Good morning, Judge Johnson. Jacob Schwartzberg, P226 on behalf of Mr. Brothers, who's on video. Mr. Brothers, would you please tell the judge your first and last name?
Purvis Brothers.
All right, so Mr. Brothers, you're here for a show cause hearing for failure to pay fines and costs on the city case. And in that matter, it was an allowing an unlicensed driver to drive, and it was alleged that you failed to pay the fine of, looks like it's now $506 pursuant to the court's order to pay. And so you're here today to show cause why you should not be found in contempt of court for failure to pay. And we had adjourned that particular matter for you to pay in full. So I don't see any receipts showing that you paid. So okay, so what do you mean you know?
Oh, I'm sorry. Your Honor, if I could get put on a payment plan or not get out of this recovery, I can put like 300 on it. March 9th, as soon as I get out of here. I just gotta get a hold to my belongings.
So that brings us to the other matter before I deal with that, which is the state case, which I believe Mr. Schwartzberg, were you on city case? I don't think you're on that one. You're on the state, which is a violation of probation.
Violation of probation.
Yeah, that's for domestic violence. And so when we were here last time. That got adjourned because the defendant was in Christian Guidance Center in Detroit. And we adjourned it for the probation officer to call and create some type of report, which we do have. And the allegations here were, let's see when they date back to. So the allegations for violation date back to October 31st, 2023, when it was alleged that you had failed to report to probation, failed to attend the HEAL program as directed, failed to complete your alcohol drug screens, failed to pay fines and costs as directed. And then, let's see, and then it looks like April 24th, okay, 2024, that might be the most recent one. It was added on also to those allegations that you failed to complete your community service, failed to verify that you were employed, failed to abide by the no contact order pursuant to a new incident report, and failed to verify that you were in anger management and failure to clear up your outstanding warrants. So those are the allegations. And of course, you have a right to have a full hearing on those, or you could plead guilty after having spoken with your lawyer. So I guess I'll ask Mr. Schwartzberg, what would he like to do on this?
Brothers would, please guilty, pleading violation, Your Honor.
Okay, and he did write the court some kind of letter that we got on the 9th, which was a couple days ago. Oh, not her, somebody, Miss Craig.
I haven't seen any letter.
Oh, yeah, it's in the file. She basically makes a full statement, which has nothing to do with this probation violation. So, sir, is it true that you wish to waive your right to a hearing and plead guilty?
Yes, plead guilty. Yes, Your Honor.
Anybody force you or threaten you to waive your right to have the hearing?
No,
Anybody promise anything?
no,
And you're waiving that right freely and voluntarily after talking to your lawyer?
yes,
All right, so it's true that you had failed to report to probation, failed to attend the HEAL program, failed to complete alcohol and drug screens as directed, failed to pay your fines and costs off, failed to turn in proof of community service, as well as picked up a new case, which would have violated the no contact order, and did not verify that you attended anger management. And then there were some outstanding warrants as well that you did not clear up. Is all that true?
yes.
Ladies and gentlemen, you are being hit with an obligatory Colin pause. Thank you very much, Colin, for the raid. I just want to get the Colin raiders up to speed. This is our first case of the night. This guy's been a very bad boy. For more information, check out the description. This has been your obligatory Colin pause. Back to the program. Already in progress.
Second, Your Honor. Number 6, you didn't mention, failed to
Verify employment. That's true too, sir?
Yes,
All right. And that's also a sufficient basis here for the plea. And I will accept it, finding that this plea is freely, instantly, voluntarily, accurately, and knowingly made. So, I don't really know what the excuse is here, sir. Looks like you were on a status, probably either, I'm assuming it was domestic violence diversion status, but if not, it was likely HIDA or something. Let's see what it was. Yeah, it was a spouse abuse diversion. So what happened? This just got away from you, huh? Back in
yeah, I
2020?
was just, yeah, and I was just juggling with 2 probations, like the case that I got now, which I'm getting done with. That's why I'm in here, just juggling with 2 probation, you guys, and then Wayne County. It was just hard to juggle, so just trying to get everything behind me now that I got a daughter and everything. Just time to be a man, Your Honor. That's it.
How do you have an 8-month-old daughter with this lady who was the alleged victim of this case when there was supposed to be no contact? How does that happen?
Just fell in love. I'm sorry, Your Honor. I don't know. It's just,
Okay. Well, that don't help that does not help your case.
I
That's
know.
ridiculous. Fell in love means you didn't even get this case in the first place. So I don't even know how that's possible. This is domestic violence. And we gotta take this stuff seriously. Because these type of cases is what ultimately, as they progress, could get people hurt and killed. So we don't joke about these. What did you want to say, Mr. Whisper?
I retract that, Your Honor. I have nothing to say.
And then we get a letter from her talking about she don't have any ongoing fear.
She wrote a letter.
And she don't think he's a risk to her safety or the safety of a minor child, which isn't even supposed to be here. Because they're supposed to be apart. Oh, she said he's appropriate behavior, accountability, sincere in his efforts to avoid conflict or avoid the criminal justice. Couldn't be that serious because he didn't do anything here. How serious can I believe this letter at all? Says you didn't do a thing that we asked you to do on this probation. Talking about you got confused with 2 cases. I got people with claim more than 2, and they managed to comply with all the courts.
You know where your client is?
She says, okay, at least she says, I wish to acknowledge that there was contact between Mr. Brothers and myself in April 2024. And apparently since then too, since the baby's only 8 months.
Okay.
She wasn't trying to show disregard for the court's authority. Yeah, this is all just a bunch of crap. She understands the seriousness of complying with the court. No, she doesn't. She went and got a baby with the same guy that she wasn't supposed to be seeing. And then she writes me this, talking about she understands how serious it is. I don't believe none of this. And she acknowledges and respects the court's no contact order. Well, I'll be dog. Yeah, she acknowledged and respects it so much, she made sure she came back with a baby. And then she talked about how you're responsible as a parent. Okay, maybe you are. I don't know about that part. And then she says the conduct resulted from poor judgment and immaturity on both sides. She takes responsibility for her role. Well, she led you down a bad path if she's taking responsibility. Because you had no business doing that. Following her, going over there, seeing her, accepting calls, none of this. Then you would not be in any trouble. You should have been focused on trying to do what you needed to do. And at the right time, you might have been able to get back with her. Y'all just did this backwards.
I'm sorry, Your Honor.
What she's talking about? She believes both of you learn. She respectfully requests the court consider a disposition that emphasizes rehabilitation, continued compliance with court order. I can't do anything to emphasize continued compliance with court orders other than put you in jail. That's the only thing I could do because I emphasized that at first. And I gave you an opportunity not to have this on your record. Get away with no conviction. All you have to do is do right. And even if you failed a little bit, show good faith and do most of the things right. Then, I said he came back with an 8-month-old baby. Then she says, if deemed appropriate by the court, I also respectfully request consideration of any future modification through proper legal proceedings. Listen, y'all don't go through proper legal proceedings. Y'all been seeing each other all this time. The only thing stopping her now is I guess she just drive over to the guidance center where you already see her there. So I don't know what you all are asking my permission for. And she could go see you at the county jail if you end up there too. You all have done it your way all this time. Now you want to ask for legal authority to do it, which she could have easily come back to the court 2 years ago and said, hey, I know there's a court order. I'd like to lift a no contact. I got people do that all the time. All the time. She didn't do that and writes me this little unbelievable letter for several years, 3 years to the fact later, asking for something to be done, right? Did you want anything else, Mr. Schwarzberg?
No.
Because I'm mad. I'm not happy with him.
We'll stand.
The people wish to be heard.
Defer to your judgment. I'll just note that it's evident that the defendant has not taken anything that the court has ordered seriously, and I don't know that we're going forward.
Well, whether he improves is up to him. He could have done this right. He could have improved throughout this probation, and we'd have been proud of him and happy about it. Then he could have been back with the girl that had a baby if that's what he wanted to do, but he did none of that. He didn't make sure he was better. He didn't take any of the counseling we ordered, nothing to ensure that whatever his issues were would not pop up again in a relationship. And without addressing your demons, sir, they're still there. And they will pop up again. I don't care what she said in this letter about how you acting now. Yeah, let the one wrong thing happen. And whoever you were when this happened, it's going to pop back up because you got nothing out of anything that we ordered you to do. And most of this was rehabilitative, which is what she asked for in this letter. Now, we already did that. And you just thumbed your nose up at it. Like the court said, nothing. But if you're in that guidance center now, trying to do better, great.
Do you consider, after March the 9th, when Mr. Brothers, completes his program, to reinstate these, requirements and give them an.
I know you're kidding me, right? No, I'm not reinstating anything here. There's no way. It's been 3 years, I got nothing. I'm glad he's doing whatever he's doing, but he's got a penalty to pay. So, sentence of the court here, he's going to pay the money that he owes us, which is $1,716. We'll put him on a payment plan for that. Plus, he's got $100 in violation costs. Plus, he's going to have a $150 counsel fee for the violation. And we're going to revoke his 769 4A status. So this conviction will now enter on his record. And he's going to do some jail. He will report to the Oakland County Jail on March the 10th. Today, after I guess he's released out of the guidance center for 30 days. His probation is terminated. Now, if you don't report to the Oakland County Jail on March the 10th, look for this to be more time. Look for it, because that's what's going to be. I'm not playing. It takes a lot to get me riled up, and you've done it. That's it. Thank you, Mr. Schwarzberg. Mm-hmm. Are we ready off a while? Case number 25S01285FY, State of Michigan versus Hussein. Oh, you know what? I need to deal with Mr. Brothers' other thing too. Hold on. Go back to Brothers. I'm gonna refer him for a payment plan on this other matter, Mr. Brothers. On your allowing an unlicensed driver to drive. We'll refer it to the collections for a payment plan And we'll make it, let's see, since you're going to jail after you get out in March. So we'll make your payment plan start sometime in May.
How long do I have to do, Your Honor, in Oakland?
You're doing 30. You'll get some credit though. Some
Any
good
credit-
time credits.
Any
I
credit,
don't,
Your Honor?
I don't know how much, but they'll give you some good time credit. How much is it on 30? Like,
One thing, 35.
so 5, 10, 15, 20, 20. So you'll probably get 6 days credit. So we'll start your payment plan when defendant gets out of OCJ. And they will send the payment plan to your street on Yale Street in Westland. Hopefully you're still there. Oh, did I say refer to collections on that one too? Okay, now back to Fawaz.
Ready.
Thank
But
you,
you're
Your
all
Honor.
set, sir. Good luck to you.
Me too.
Okay, this is case number 26S00082OM, City of Southfield versus Tremaine Hodge. Good afternoon, Mr. Rivers. Miss Hodge, yes, there she is. All right, come on up, tell us your name. And Miss Hodge, you are here for a pretrial on misrepresentation of identity with intent to obstruct the police, which is a 90-day misdemeanor. Here's up to $500 fine. You certainly have a full right to have a trial on this charge, could be by judge or by jury, with a lawyer to represent you. And if you couldn't afford a lawyer, you'd like to have a lawyer, then we'd make sure someone was appointed for you to represent you if you're eligible. So you understand that? Okay, so Mr. Rivers, you had a chance to speak with her today?
Yes, ma'am, I did speak to Ms. Hodge. We did work out a resolution agreement where she would plead guilty as charged to the misrepresentation to the police. And at the appropriate time, I would recommend that she be sentenced to time served.
Okay, Ms. Hodge, so although there is no plea bargain, prosecutor wants to recommend time served. Of course, I don't have to follow that, but I would take that into consideration. So is that what you'd like to do?
Yes.
All right, let's go over all of the constitutional rights that you do have at trial that you're getting ready to waive because you're pleading today. So if you understand these rights, all you need to do is say yes as we go over these together. So, okay, we're going to start with the fact that, again, you have a right to have a trial by judge or by jury with a lawyer. And if you couldn't afford one, we'd make sure someone was appointed to represent you. So you understand you're waiving that. And at that trial, though, you would also have the right to subpoena witnesses. That means you have the right to ask the court to order witnesses to appear to testify for you. You understand you're waiving that. You have a right to question through a lawyer any of the witnesses that are brought against you by the prosecution. You understand you're waiving that. You have a right to testify on your own behalf at trial. But if you choose not to testify, no one can hold that against you. You understand you're waiving that. Also, understand that you have a right to be presumed innocent unless you're proven guilty beyond a reasonable doubt by the prosecution at a trial. And you're going to waive that. You understand? And if you're on probation or parole status now, and you plead guilty today, this plea might be considered a probation or parole violation. So you understand that. And you have read and signed the advice rights form. Any questions about your rights? Understand if I do accept the plea today, that you won't have a trial and you'll give up all the rights we're talking about, the rights that are on the form. Yes. You also understand the potential penalties that are involved here with this charge is 90 days, $500 fine. And you still wish to plead guilty to misrepresentation of identity to the police with the intent to obstruct. Anybody force or threaten you? You've been promised anything other than what we stated, and you're pleading freely and voluntarily. Is it true this occurred January 27, 2026, 12:12 a.m. at 22305 Telegraph Road, City of Southfield? Let's see. Well, were you there, first of all? Okay. Now, were Southfield police officers also present in uniform or in cars such that you could tell they were Southfield police officers? And so were they there in the performance of their legal duties, investigating a stolen vehicle or larceny investigation? And did they ask you to identify yourself? And did you tell them your name was Aliny Hodge? Okay. Okay. So when you did that, did you tell them your date of birth was April 28th of 2001?
Yes.
Okay. So when you put those two together, you knew it was not true. And you did that with intent to obstruct their investigation into your identity. Okay. All right. You satisfied?
People are satisfied, Your Honor.
And I'm satisfied as well. Factual basis for the plea, court rules been complied with, and I found the plea is freely, understandably, voluntarily, accurately, and knowingly made. Who is Aliny Hodge? Just somebody you made up? It's not a relative. Okay. Why'd you make that up? Well, don't you know the truth? Never heard the truth shall set you free. If you had told them the truth, you wouldn't even be here on this charge.
I was really trying not to do so good off the road, and I was like,
Well,
I think that I'm like good, and I'm like,
see, now that's your problem. What dude did you meet? And you in the car with the dude? Were you in the car with him?
Yeah.
He was driving?
and he had a buddy as well, but I didn't know the buddy.
You in the car with men you don't know?
Be home. Like,
Are you serious?
Like literally, my car had broke down, and
Ma'am. No, ma'am. We don't get in the car with people that we don't know. Do you know what's going on out here? Girls are just disappearing. Women, girls, people. Now, what if they were bad guys? You don't know who they were, and you in the car with them? What if they'd stolen you and did what they wanted to do to you and then killed you? Right? Was that pressing for you that you would get in the car with a stranger like that? And who knew you was in the car with them? Okay, and you don't see nothing wrong with this picture. So why not you thinking better than this?
I'm ready to I'm trying to be back for him.
Okay, no, but the chances of you getting back to her was maybe 50-50, if that. It might be good the police did stop the car, because maybe they would have got you there and maybe not. You got to be more careful with yourself. You only got one life. And if you had told them who you were, you wouldn't have this case. Maybe this case saved you, because if you had told them, maybe you would have kept going in the car with them and maybe you might not have got there. I don't know. But that's something for you to think about, isn't it? Because I don't think they were going to charge you with the car. Obviously, they didn't. They just charged you because you didn't tell them who you were. And so you could have gotten out of any problem with your parole because you would have had no problem. No charge about the car. No charge about a name. Now you got to explain the name problem. And you know what parole officer wants to hear? That their parole assigned person is trying to pull one over on them by giving a fake name so they won't find out. No, they don't want to hear that. They want to see you thrive. That's what their job is, to get you back on track, get you employed, make sure you're following the rules, get you back where you're supposed to be. What you on parole for anyway? A guy or girl?
Oh, yeah. And I do regret it. I'm not even.
Okay. Cause young, yeah. You're gonna have 2-3 more great loves. It don't matter. Let the first one go. Everybody had one. First one that broke their heart. Everybody's still moving. Very few people marry the first one. Some do. Very few. So you gotta start making better choices. Because when you think about even that can't make the guy like you. It don't fix nothing. He gets you in jail and he's gone on with whoever he want to go on with. Might not even be the other person that he broke up with you for. It could be anybody else. You gotta hold yourself a little bit higher esteem than that. You have value. Your life is worth more than arguing with some man to make him like you. If he don't see the prize, that's his problem. Don't mean you not the prize. I mean, he's blind. And that's okay too. He might have regretted. Now, he can't regret it now because he's thinking, well, she crazy now. Yeah, you know he's thinking that. He cannot regret that now. But that's okay. You know, you just got, what are you trying to do for yourself?
I'm trying to push myself through school. I want to be a lawyer in real estate and just trying to start my own clothing line business. I'm just trying to make my name again.
Well, that's good. Well, I'm not saying you can't be a lawyer because, you know, when you pass the bar, they got a character and fitness portion. Well, you got to explain away convictions. Some people can do it and they get past that. So you just got to stop getting in trouble because this is one you didn't have to have. You're running your chances of getting your dream done. Every time you do something like this, you got to start. And lawyers are paid to think, and you're not thinking. Not saying you're not smart. I'm just saying you're not thinking. It's two different things. So if you concentrate on your goals, I think you can accomplish them. But you getting sidetracked on all kind of dumb stuff.
And I'm like, I'm very frustrated, and I'm like, I feel like, my second chance, my last chance, I really got to get that right.
Yeah. Well, ask him for some discernment and for some guidance. And to make and to order your steps. That's what he can do. But you gotta ask him for it. Say, look, order my steps. I can't do this on my own. I done made too many missteps. Yeah, who is? That's what I'm saying. Everybody's imperfect. We're perfectly imperfect. And we've all made mistakes and done things that no matter what it was that we regret somehow, but it's okay too, because all you got to do is ask for forgiveness, pray on it, and then that's what he does. He forgives. Then you ask, you give your thanks, and then you ask for your direction. Because this right here is just nuts. You didn't have to have this. And you've been in there since the date of the incident, since the 27th. So how many days is that? 1, 2, 3, 4, 5. That's 16 days. So you're gonna promise me that when you get out of this one, you're gonna report to your parole officer. You're not gonna get any cards with people you don't know. You're just gonna stick to trying to get your job, stay in school, stay close to home with mom. You can get a man anytime, but you get yourself together first. That way you don't need him. He's just a great asset to you. Because that's what he should be, an asset.
I promise, but
No, you should promise. You should promise.
well, I'm not gonna say I wasn't gonna promise, but I will honor that.
Okay, well, okay, honors. I'll take that. Take that, because I really don't want to see you back here on anything like this again. So, 16 days of jail credit for 16. I'm not even fining you. Okay, good luck. Okay.
This pains me to see this. It really does. I know it's only $2,000, but $2,000 is a lot of money. Bring all your documentation that shows me she paid you. You paid her. If you took cash out, you can go to the bank.
I had
Wait.
cash. I don't,
Wait, ma'am, Ms. Hernandez, I'm going to find out who's lying to me. It doesn't matter to me who's lying. I'm going to, ma'am, ma'am, ma'am. I'm gonna find out who's lying. You guys just make this hard when you do this, like with a handshake.
My mistake.
You didn't make a mistake. You don't have to apologize to me. You might be out when it's your burden of proof here. But I can tell somebody's lying, and I'm going to tell you who it is when we get here. Bring all your documentation, Ms. Hernandez, okay? That tells me
Okay.
that you paid this. Guys, I mean, you say you have a security, you filed a pleading saying you have a security agreement. Do you know what a security agreement is?
I was going by what
The bank,
lawyer told me to write down
don't tell me what the lawyer told you. That's between you two. If I went to a bank or I went to a dealership and bought a car, that's when I will execute a security agreement. I doubt that you had her execute a security agreement.
No.
Why'd you allege it in the complaint? Shh. Give me all your documentation. Did you ever sign a note at least?
We had this agreement that I gave you a copy. You should have a copy of our contract.
Okay.
And she signed for the 2 payments that she did give me.
She signed?
She signed, yeah. The 2 payments, one on,
Oh, man, that's kind of telling, Ms. Hernandez.
and it says in the
You
contract.
guys come up here. Come on, get dressed. Come on up here. But I'm telling you, I'm going to have you guys under oath and I'm going to resolve this today. And you guys are going to, you're going to be honest with me because I'm going to find out who's lying to me. Okay? I'll see you whenever you get here, Ms. Hernandez. Unless it's really, unless you guys want me to adjourn this for a week or so, I'll be happy to do that.
Well, I'm volunteering today where I live.
Where do you live on Riverside? What do you mean you're
Yeah.
volunteering?
At the towers where I live.
Ms. Hernandez,
Yes.
why don't I do this? What do I have tomorrow, Jennifer?
Tomorrow is the 11th. You have Brownstown and Groseal reps. So let me see.
It's easy. All right, 8:30 in the morning. Can you be here tomorrow, Ms. Hernandez?
Yes.
Can you be here tomorrow at 8:30?
Yes.
We're starting at 8:30. Do I have sentencings on that docket tomorrow?
No, I don't see any sentencings
Good.
at 8:30.
Perfect. 8:30. You guys be here. Don't make me wait. All right. Leslie Bolsujor versus Cynthia Hernandez. 2504922.
Right to the podium. Stand right next to him.
You all right?
Yeah.
Okay, tell me your name.
Cynthia Hernandez.
Your name?
Leslie Bolsage.
All right. You two want to go talk about this before I start swearing people in?
No. I know.
Just relax. Let me just read something that's attached. Wow, you did actually draft something here. I don't know who drafted this for you, Ms. Bolsajor, but I could make a case that this is This is a security agreement. I'm gonna do this a little different. Right now, the car is titled only in Ms. Hernandez's name. Bring any documentation with you that tells me that you made the payments?
Me?
Yeah, you. Now, before we go on, I'm gonna scare everybody to a note. And I'm gonna try to do this a little different. But I want you to know you're under oath. I'm gonna ask both of you to raise your right hands, please. You solemnly swear or affirm under penalties of perjury that the testimony you'll give of these proceedings will be the whole true self you got. Ms. Bosager, Ms. Hernandez?
Do.
Let me see the proof that you have that you made the payment. She attached to her complaint documentation that does spell out that you were to pay $3,000. And there was a payment made on October the 2nd that you, by the way, initialed of $500, and again on November 5 of $500. Do you have any more documentation that indicates that you made any other payment? Let me see what you got.
That right there, that's her.
Whose writing is this in?
Not writing. And then on the back is what you was right.
Oh, wait a minute.
Those are my notes and then.
Ma'am. You're under oath. On the first two payments, you guys both initialed the $500 payment. And then you just added 2,000 paid on September 25th that you wrote on the back of this, right?
That was the notes I kept from the day that we put the car in my name, the day that the Secretary of State that I gave her money. That's when the title that I had went into my name. She kept notes, I kept notes. Oh, I wrote a contract. Yes, speak your own.
No. I want to know if that's your story and you're sticking to it because you're under oath. This is going to be easier than I thought. Are you telling me you paid her $2,000 on September the 25th?
Yes.
How'd you pay the did she pay you $2,000 on September
No,
25th?
Your Honor, absolutely not. Didn't have the money. She had to bail herself out of jail. That's why I offered her my college.
Come on. Come up in front of my report. Show her that document. You ever see that page?
No.
I neither. Mr. Hernandez, who do you think that you are coming in here and trying to
What?
put that back? Give me that back, please. Who do you think you are coming in here with notes on the back of that document,
That is horrible.
expecting me to buy this? And now you come in here defiantly and no, I don't want to talk. I don't care if you talk. You owe her $2,000 at minimum. Okay? How are we going to resolve this? I'm sorry?
You said I don't want to talk. I just want to be asked. If you ask me a question, I will definitely answer it.
You didn't pay. You didn't pay.
On September 25th at the Secretary of State. And here,
September 30th is when you guys executed this other document. You signed it October 2.
that was when I gave her $500 on October 2nd.
Ma'am,
2 payments.
I don't want to hear it. I don't want to hear it. I don't believe a word you're telling me. I don't believe a word you're telling me. There's nothing here that would add up to you paying $2,000. So if you want to act like I can't add 2 and 3 without a calculator, just you continue doing that. You're late, Mr. Robertson.
Everything was cash, Your Honor.
I wouldn't expect you to, ma'am. You're in a courtroom. Okay? I don't want to hear another lie. You're in a courtroom. There's nothing here that adds up to you paying that $2,000 in cash. This was dated October 2 by you. This first page. Is this your signature?
Title is dated 25th of September.
Ms. Bosajor. Can you come up here? You come up here too. Whose signature is this?
My signature.
Okay. Why would you sign something October 2 saying that you agree to pay $500 per month beginning October 1 with the last payment due on March 1? That would be 6 payments at 500. 6 times 5 is 300. Now you come in with this cockamamie document on the back that you hand wrote and says you paid $2,000 on September 25.
That was the second document that was made up. There's copies.
Quit while you're behind. It's 82-0. There's 2 outs, 2 strikes, and nobody on. Don't lie to me another second. I'm gonna really get agitated here. I told you not to lie to me when you came in here. I told you not to lie to me the other day. I sensed that you were gonna come in here and lie to me. I kept an open mind, and here it is in black and white. There's no judge in the country that's going to be convinced that you paid $2,000 on September the 25. Ma'am, you just decided to fabricate a document here. That's all you did. Ma'am, talk to some other judge, some other place. You're going to figure out right now how you're going to pay her $2,000. You guys, though, Ms. Bosajor, I don't know what to tell you. You just can't do this and trust people. Were you guys friends? Were you friends?
I dated her brother in high school and we were Facebook friends. and she contacted me via messenger on a social media ad, and I should have never answered the phone. I really should have. I did all kinds of stuff for her.
You're gonna go figure out where you're getting it. Hang on. You're gonna go figure out where you're gonna get the $2,000 today. Then everybody will be happy. So sit in the back. Figure out how you're coming up with $2,000 today.
I don't have $2,000.
Well, you had enough gumption to come in here and lie to me.
I'm not lying.
You're lying to me, ma'am. I see the title.
That's what?
You're lying to me. There's no way. You signed a document, the one I just showed you. It said that you were going to pay $500 payments starting October 1. And you made a payment on October the 2nd that you both initialed, saying you paid $500. Then you paid another $500 on November 5. Then it's blank. If you'd have paid on October 2 and November 5, the car would have been paid off. There's no indication her initialing anything. This is what happens when things are done in cash. Ma'am. I'm making my ruling. And I'm telling you, I don't know what I'm going to do right now going forward. You're not going to come into this courtroom and lie. Well, you're just under oath. That's perjury. Perjury. It's one of the easiest calls I've had in the last 17 years. Maybe 31 and a half. You figure out who you're going to call to come and get the money to pay this lady. Right now. And then we're going to go from there. I'm going on to another case. Now, I could make you transfer the title over to her because you violated the terms of this purported security agreement. But I don't think that's fair with her. To her. You're going to figure out how you're coming up with $2,000, but you're not going to come in here and lie to me. Jeremy, Kristen, have a seat, you two. Jeremy, Kristen, Antonio, Robertson, 255W837064.
Good morning, Your Honor. Josh West, here on behalf of these one.
Good morning, Your Honor. Peter Granata, P78413, MIDC counsel for Mr. Robertson.
Robertson, you're late. You knew I was going to do this at 8:30 to not interfere with another judge's docket. You come strolling in at 9:15. Why? It's not good enough. Your name? All right, so this can be a plea to disorderly conduct. There's the prosecutor is going to move to dismiss the retail fraud, and there's agreed upon restitution of $11.46 to Lowe's, correct?
Yes, Your Honor.
And is that correct, Mr. Granata?
Yes, Your Honor.
If you plead to this, possible penalties are up to 500 fines, 90 days jail, costs for all those. Do you understand that?
Yes.
You are presumed innocent. You need to wear those sunglasses. Do you have some eye issues?
Slightly innocent.
Is it an eye issue or you just feel like wearing some?
Right, license.
If you plead guilty, you're giving up your right to a trial. You're giving up your right to remain silent. You're giving up your right to question their witnesses at a trial. You're giving up your right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence would not be held against you. By pleading guilty, you're giving up all those rights and we won't have a trial. Do you understand that?
Yes.
You agree to plead guilty to this charge.
Yes.
You understand the possible penalties, and that along with it, you're going to pay $1,146 to Lowe's through the court in restitution.
Yes.
To the charge disorderly conduct. How do you plead?
Yes.
Were you at 21,000 West Road at Lowe's, May 31 of 25 in Woodhaven?
Yes.
And did you commit the offense of retail fraud by stealing property that was valued at $1,146 that was not recovered?
Yes.
What kind of property was that?
Those right.
I know, but was it toothbrushes? Was it loan? What was it? I mean, come on. I know it was Lowe's property. What kind of lawn equipment? Lawnmowers?
Lower.
What else?
Lead house.
And you walk past the register somehow without paying for those items
Yes.
with the intent to deprive them of that property? Are you on probation or parole?
Yes.
For what? You understand by pleading, were you on probation, or parole on May 31 of 25.
Yes,
And that's for CCW.
yes,
You understand by pleading guilty, this would be deemed a violation of that probation or parole, and that parole or probation could be revoked as the case may be, and you could be incarcerated. You still wish to plead guilty?
yes.
Anybody force you to plead guilty? Please accept it. Did you guys ever get that, I'm gonna accept your plea to disorderly conduct, dismiss the retail fraud, order a pre-sentence report? Was there any indication, counsel, did I ask your appearance since we started on this? Okay. Was there any indication of alcohol or drug use or anything?
No.
I'm gonna order a pre-sentence report and a sentencing date.
Was a co-defendant, Your Honor, that's not.
I see. All right, give me a sentencing date. Heather, we're going to make sure this stays on my docket day. This is an off day. So what would that be? Like March the 2nd or something?
Yeah, March 4th, Judge.
March 4th. And we'll do this at
I will
8:30.
be in court March 4th as well.
Okay, March 4th at 8:30 a.m. Okay? You're going to go down the hall, get your notice. Then you're going over to probation where you'll fill out a question. You're going to be interviewed, okay? Wish you well. Good luck.
Mr. Robertson, I'll call you tonight.
Thank you.
Your Honor,
Thank you, Judge.
Saunders,
trustee Holland.
Trevone Terrell Saunders, 19M714-639FY.
Morning, Your Honor. Michael A. Carton, B738, for defendant.
Did we, your name?
Trevon Saunders.
All right, counsel, let me check. This is an old case. Where you been? You live out of state?
Yeah, I was incarcerated in West Virginia and Pennsylvania.
Nice. So we have a possession with intent to deliver less than 50 grams of fentanyl from 2019. For purposes of arraignment, how does he wish to proceed?
Your Honor, thank you with reading.
All right, sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. Again, you have the right to remain silent. If you choose to submit the law questioning with law enforcement officials, and you don't have to do that, then I do want you to understand that you'd be entitled to a lawyer at that questioning as well. Your probable cause conference, you'll be in front of Judge Hessen, will be February 24th at 9:15. And the preliminary exam will be March the 3rd at 11:30. Okay? Do you understand that?
Oh, yes, sir.
So we're gonna have you fill out a petition for a court-appointed lawyer going forward. I'll listen to whatever you have to say, counsel.
Your Honor, as my client did mention, he has been incarcerated in Pennsylvania and West Virginia from 2020 up until the very end of 2025. He is currently though staying in Detroit with his mother, 3250 3rd Street. I did write his
32, wait a minute, you wrote it down somewhere?
well, I'll give you 3250 3rd Street,
Okay,
Detroit.
okay.
But I did write his current mailing address, which is in Pennsylvania on the ROA.
3250 3rd, is that 3RD or THRIRD Street?
THIRD.
And you have that zip?
I think it's 48226. So he's staying with his mother. He can stay with her until whenever, until however long he needs, so this case gets resolved.
Does he work?
Until
Yeah, do you work?
No, I'm in CEO class. 3 weeks exactly left.
Where was he picked up at? Do you know?
Shorey, in Shorey, I was at the gas station. I was driving my car, came up here and they pulled me over and said I had a warrant. But I thought it was clear, so.
Your Honor, he does have a valid driver's license and insurance to be able to get here from staying with his mother in Detroit. Also has 4 young dependents that he helps take care of.
He had to know about this warrant and he didn't surrender on it. 100,000, 10%. You cannot leave the state without the consent of the court. Cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. This is the state police, so we're gonna have to get on this and get them to get him or what have you, John. So make sure they take care of that. And also, I want to check and see if he was ever printed on this case. I don't believe so. And you weren't printed, so also you have to be printed and photographed. So we'll have to tell them when we call over to the state to have them get them, okay? 100,000, 10%. You're gonna have to post $10,000. No
The
mail.
state trooper is here in the.
Oh, he is?
Yes, sir.
Where is he? Oh, I'm sorry. I
Can
didn't
I have him chime in on bond?
chime in on bond. You want to come on up here? What, you want a lesser bond than that? Is that what?
100,000, 10%?
He hasn't been here. Come on. Your name?
Detective Sergeant Mark Lamb.
Did you want to say something on bond?
Yes, he has been incarcerated as an overcharge. And me and him had conversations and I did. Off the record.
I see. Why don't you and the defense lawyer approach? Come on up here.
Yes.
So you want to become personal bond? Yes. All right, so you want a different bond. Tell me what you're asking me for, trooper.
I said, since the duration and conversations, I wouldn't mind having them push them by.
All right. 100,000 PR. Make sure you show up. You understand that?
100%, sir.
All right, 100,000 PR, those are the terms, but he's gonna have to get printed today too,
I
okay?
can take it to post.
Thank you very much. You'll be released. Good luck.
Thank you.
Thanks.
Thank you, sir.
Is she coming down, Ms. Hernandez?
He said he yelled for her twice, she didn't answer, he thinks she might have left.
Good morning, Judge.
Good morning. Recalling Leslie Bozajor versus Cynthia Hernandez, 2504922. Your name again? I'm not sure what I want to do. What, do you want the car back?
Sure. I can resell it. Even if it's damaged.
What does she think she is leaving like that?
She's not somebody I thought I don't know who she is, Your Honor.
You got to be careful in the future.
She knew my husband had just passed away and I was living alone and vulnerable. And I think she just took advantage of my,
I don't know what. Jennifer,
Yes, Judge.
do me a favor, call Ms. Hernandez. Tell her I expect her to be back up here in 10 minutes. Leave her a message. If
I can
not,
see if there was a phone number provided by plaintiff.
I'm just not sure what you want to do. You made a lot of mistakes here. You signed the title over when you didn't have the money. You didn't list yourself on the title as a secured party. You took cash. You didn't take it. I mean,
I came to your civil department to find out what I should do.
well, they can't give you
No,
advice.
it's gonna give me a number to a lawyer and that's who I spoke to.
Well, I don't want to know what your lawyer told you. And I don't want to know what you told
But
your
that's
lawyer.
how I filled out the papers.
Well, it's fine. When I looked at this, you do in essence have a security agreement. But this is unique because like if you went to a dealership and you got a loan, the bank's name is going to be on there as a secured party. Your name is not on the title as a secured party. Do you know if she works?
No, she's on disability, I believe. She gets $1,000 a month plus food stamps, and that's why she's living at the towers, because it's rent, adjusted. You only wanted to make $250 payments for my car, but I told her no, that would take a year for me to pay it off. Yeah, no, I told her, you said you have to make $500 payments. That garbage she wrote in that paper she gave me.
Ma'am, I'm not, I've already decided that. You don't need, we don't need to.
Those are lies.
We don't need to, I said that 6 times to her. I know, we don't need to revisit that. I'm trying to think of how I can help you. Ma'am, I said 6 times. Anybody listening would have listened and understood that I was calling her a liar. Okay? I mean, there's no question about it. I don't know how stupid she thinks I am. I'm just trying to figure out how I can help you at this point. You got somebody with a title, somebody's got no money, somebody's on disability. They don't have a job where you can garnish wages. Even if I give you a judgment, you got nothing.
She's on probation.
It doesn't matter. That's wholly different. I'm not shocked by that. Is she in front of me on that?
No, first district court.
I want to think about this. I got to think about this one. I don't know how I'm going to handle it, to be honest with you. That's going to be best for you.
Whoever's easiest to resolve it, so, we can put it behind me.
Yeah, you gotta next time talk to lawyers before you do these things, okay?
Yes, sir.
I feel like going to the Wayne County Prosecutor's Office over this one. That's how certain I am that perjury charges should be filed. I need a week to think about it, okay? Reschedule this for hearing and I'll figure out what I'm gonna do by next week, Jennifer. This is kind of a curveball, so we're gonna give you a date down the hall. Mail it to Ms. Hernandez too.
Okay.
I don't know, I might have you. I just gotta think about it. I'm sorry. All right, set it up for next week sometime, Jen. You
Okay.
know, it's gotta be at least Wednesday though, right?
Right, because we got to give
I-
7 days.
Exactly.
You
Okay.
have a couple landlord tenant things in the afternoon next Wednesday that you
That's
had
fine.
set. Okay,
That's fine. Thank
we'll do it 1
But just
o'clock
remember, next Wednesday, I've got sobriety period starting at
at
3 too.
3:30. Yeah, or 3 o'clock. Yeah.
Right, thanks.
She was PC attorney, she's supposed to be the prosecutor, so I was gonna give it to the Brownstown prosecutor.
Okay, so you're gonna show up next week. She'll give you a notice down the hall, okay? I'll come up with something. I'll think about something, okay? No problem.
Zito Chansey versus Cedric Hudson and Property Rental Company. Let's go ahead and hear that.
Okay, good morning, Your Honor. This is the date and time set for the damages hearing. I only have one witness, that's Mr. Chansey. I see him on the call today. I just want to give a brief opening statement because, as you know, the only issue today are the damages. Mr. Hudson is in default by way of an order striking his answer for failing to participate in discovery, and Property Rentals in default because they failed to file an answer for over 3 years. This is a dog attack case, so all elements of viciousness or negligence are deemed admitted. This is a case where 3 pit bulls attacked my client when he was walking past the property at issue, and he's going to give testimony today about how that impacted him. Mr. Chansey, are you there?
Yes.
Okay. Would you raise your right hand? Do you swear or affirm the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. Mr. Chansey, I want to just talk about, let's go to the moment of the dog attack, and can you walk us through what you remember happening?
I was walking outside the backyard, going to the front. I was on my way to go shopping. And then on my left-hand side, the gate had a hole in it, and the dog had his head sticking out of it. Now, it shocked me because I thought it couldn't go through it. So then I kept walking, and then I turned my back, and then a dog came out barking. And then I thought it was going to go away, so I shoot it, and it didn't go away. And then it started barking. Then the other 2 dogs came out, and then all 3 of them ganged up on me. So one bit my leg, and then one tried to jump at my face, and one tried to jump at my hand, and I was fighting them off. And then I forced my way. One was like pulling me in my leg, trying to get a better grip. I climbed on the car to get away from them. Then they finally got off me and left. Then I got off and laid on the floor, and then people came out, and then they called the ambulance.
And were those 3 dogs, were they pit bulls?
Yeah, I think so. Yeah.
And you mentioned, go
Mr.
ahead.
Samuels, I know that's a big thing about people thinking pit bulls are vicious, but any dog can be vicious if they're not properly trained or raised. So the fact that it's a pit bull, quote unquote, doesn't really hold much weight with the court.
Understand, Judge.
Roman free can be vicious.
No, that wasn't what I was getting at, Your Honor, because any fault's admitted anyway, and viciousness is deemed admitted anyway. Laying foundation because we have some reports later that are going to be entered into evidence. And Your Honor, I'm about to display photos of the injuries. Is that okay to put up on the screen?
Well, I do tell you that we live stream. So if it is anything that is of an intimate nature that he would not want on the internet, then you might want to govern yourself that way. But otherwise, you put up your proof.
Okay, we have consent to do that. It's just it's the injury. That's all.
I got you.
Your Honor, we've submitted these exhibits to the court too. I'm going a little out of order, just for the court and for the record. This is going to be pre-marked as Exhibit 6. Mr. Chansey,
Okay.
let me know when you can see my screen, okay?
Okay.
What am I showing here on screen?
It's my right leg.
And does this fairly and accurately depict the extent of the injury to your right leg as it was on the day of the attack?
Yes.
Okay. I'm also going to show you what we've pre-marked as Exhibit 7. Same question. What does this show?
The bite marks on my right leg.
And does it fairly and accurately depict those bite marks as they were on the day of the attack?
Yeah.
Your Honor, at this time, we move to admit the exhibits we pre-marked as Exhibit 6 and Exhibit 7.
It will be admitted. I guess Ms. Hune is here. You all are in default. You can challenge the damages as presented, but we're going to go ahead and let him put up his case. So 6 and 7 will be admitted.
Thank you, Your Honor. Mr. Chansey, you mentioned before that an ambulance came. What did they do for you?
They put me in a stretcher, and then they asked me questions. about which hospital I wanted to go to, and am I injured anywhere else?
And Your Honor, oh, I'm sorry, I'm getting some feedback there. Your Honor, I'll display this on my screen. We have the ambulance records certified under the business records exception with the self-authenticated authentication statute reference. So at this time, we move to admit Exhibit 1, which is the ambulance report.
Okay, will be admitted.
Thank you. Mr. Chansey, what hospital did you end up at?
The Piedmont Health Center, I think.
Was that Piedmont Henry Hospital?
Yeah.
And what did they do for you there?
They had patched up my leg, gave me some shots, but they wanted to wait to see if they could get information on the dog, if I need like a tetanus shot or something like that. And then the doctor has stitched up my leg.
Did they do any scans at the hospital?
Yeah, they did some scans.
And Your Honor, Exhibit 2, which I'll put the certificate up on screen, is the same thing. It's certified under the business records exception. We move to admit Exhibit 2.
Will be admitted.
Thank you. Mr. Chansey, you had testified before that a doctor saw you. Was it a doctor that closed the wound for you?
Yeah.
I'm going to show you what we've pre-marked as Exhibit 3. Do you recognize this as the physician bill that you incurred in connection with your stay at Piedmont?
Yes, that is.
And it reflects charges of $2,244 for the physician portion of your treatment?
Yep.
Does this fairly and accurately depict that bill?
Yes, it does.
Your Honor, at this time, we move to admit Exhibit 3.
Exhibit 3 will be admitted.
Thank you. Mr. Chansey, I'm going to show you what we've pre-marked as Exhibit 4. You mentioned before that you had scans. Does this fairly and accurately depict the separate radiology bill you had for the radiologist that reviewed those scans?
Yes.
Your Honor, we move to admit Exhibit 4, the radiology bill from Piedmont Henry.
It will be admitted.
Thank
How much
you.
is the bill?
This one is $24, and in summation, Judge, I will itemize all these for you.
Gotcha.
Mr. Chansey, I'm going to show you what we pre-marked as Exhibit 5. What's shown here?
My right leg.
Does this accurately depict your leg as it was after it was bandaged at the hospital?
Yes.
Your Honor, at this time, we move to admit Exhibit 5 into the record.
Will be admitted.
Thank you. Mr. Chansey, can you talk to the judge first about the attack itself? And what I mean by that is, can you walk us through about what's going through your mind? Did you fear for your life? What did it feel like when this was all happening?
Well, yeah, I was afraid because I didn't expect 3 dogs to come out. There was nobody around. I was yelling, and there was nothing I could really do but like run or try to get on something high. And the cars was the only thing available like around me. So I was scared because it's like I never expected like to get attacked by dogs on the way to go shopping.
When with respect to the leg, because that looks like it's the worst of the 3 parts you mentioned, how many times were you bitten there?
So it grabbed my right ankle once and then grabbed it again the second time, and then another dog bit my inner thigh. So about 3 times.
In Your Honor, I'm going to display what we've pre-marked as Exhibit 8.
Yes.
I'm still going to have my client authenticate some photos, but on this one, we have a certification from Clayton County Police Department, and this comes in because it's something the department collected in terms of its investigation and has a duty to report. Scrolling down, though, before I move to admit, Mr. Chansey, there's 3 photos here. I'm just going to go through them real quickly. Just take a look at the first one, the next one, and the last one. Do these accurately depict the injuries to your inner thigh, your knee, and your leg?
Yeah.
Your Honor, at this time, we move to admit the report from Clayton County Police Department along with the attached photos as Exhibit 8.
Will be admitted.
Thank you.
And these were pictures taken on the scene when they respond with the first responders?
Yes, Your Honor. Mr. Chansey, we talked about the hospital suturing up the leg. after your discharge from the hospital, can you kind of give the judge an idea of what the recovery was like, what you were dealing with, and how this impacted your day to day?
Well, because I didn't expect this to happen, nobody came to help me, so I had to limp out the hospital. I couldn't get an Uber ride. I couldn't, no family, nobody to call, so I had to limp out and probably get to the bus. I threw up on the way there because they gave me some medication and stuff like that. And I couldn't work, but I had to work because I had stayed in the weekly. So I was afraid that if I didn't try to limp or eventually get to work, I'm going to lose the place where I'm staying at because that place was a weekly stay. So I went to try and work at the stadium and deep fry some food. You know, it was hard to get there because it looked like I already had an issue, like I was disabled because I was walking, but I couldn't tell them. So I had to still try and work because of that, because I didn't want to get kicked out of where I was staying because I got bit by dogs. They wouldn't let me work if they knew I was injured already. So that was one of the things I went through. And I couldn't move anywhere and go back to family because they stayed too far. They stayed in a whole other state.
And you kind of touched on this, but at that time, is it fair to say you didn't have a car?
No, I didn't have a car.
How long after your initial stay at the hospital was it before the doctors removed the sutures?
A month.
How long was it before you were able to walk normally without limping or feeling any pain?
3 months.
As we sit here today, though, is it fair to say your leg is fine?
Yeah.
And there were no plans for any kind of future medical care?
No, I had to keep taking antibiotics. They gave me a prescription for like the first month.
Were there any concerns, Mr. Chancey, about rabies? Because were these dogs who were owned by somebody, or were they just randomly loose?
They were owned by somebody, but the people didn't know at the hospital whether or not they had any kind of like shots, if they been taking shots. So they gave me medication to keep taking just in case, so I don't get an infection or something like that.
Is there anything else you want to add, Mr. Chancey, about your experience, how it makes you feel about dogs now, or how difficulties you had physically at the time the injuries were at their worst before we move on?
Well, I'm scared of like seeing more than one dog. One is fine, but like more than one dog, I get a little bit iffy about, because I don't know if they might fight with each other or attack me.
Okay. Do you have scars?
Yeah.
And Mr. Chance, where do you have scars?
On the inside of my thigh and my right ankle.
All right, Your Honor, we pass the witness.
All right, Ms. Yin, and if I'm not pronouncing your name correctly, please correct me.
No, you're correct, Your Honor. I just wanted to clarify. My client did file an answer, and it was filed on the 24th of October. It looks like the complaint was filed on October 17th of 2022, and shortly thereafter, after they were served, they did file. It may not be, in the best form, but it looks like they did file. And
I'm sorry, say that again, because it sounded like you said the answer was filed before the complaint.
No, the answer was filed after the complaint.
So what date was the answer filed?
I have here October 24th, 2022.
Okay.
Your Honor.
And he filed an answer on behalf of whom?
One of the company's manager filed on behalf of the LLC.
So, Mr. Samuels, you want to respond to that?
I'm going to take counsel at their word. I haven't seen this answer in the 3 years the case has been pending, but things happen with dockets and whatnot. But assuming they're correct that an answer was filed, they have an Eccles problem. They need a lawyer filing that answer.
Yeah. Yeah, anytime in state court or superior court, if an answer is filed on behalf of a corporation, including LLCs and S corps, then it needs to have an attorney represent the corporation for the responsibilities of being a fiduciary and making sure that all interests are covered.
Yes, Your Honor. At the time when they filed it, they did it on their own. I was just recently retained, especially.
I got you, Ms. Yoon. I know you coming in on the tail end of this dog. Yeah. No pun intended. But.
Yes. Yes, so in looking at the case, I didn't see any sort of default against the LLC. After they received the notice about the hearing today, that's when they retain, and that's why they are here. You know, they take this case seriously. But after they filed that answer, they did not receive any further notices. They thought that the case somehow resolved. Based on their communication with Mr. Hudson, he's a tenant in this case, and he said that everything was taken care of until they received this notice.
Okay. All right. Did you wish to ask Mr. Hudson any questions regarding the damages that he and Mr. Samuels are presenting here today?
No, Your Honor, we don't have any questions regarding the damages.
All right. All right, Mr. Samuels, did you have anything else to present to the court?
Just to make sure we keep the record clean, Judge, I just want to see if Mr. Hudson has any questions before we move on. He's a tenant, so he doesn't need a lawyer.
Yeah. Yes, I do have a question. I don't, but I'm not sure if I'm really trying to make the right response. Do I question Chancey, or how do I ask the question? Do I ask Chancey a question about what he said as far as the dog bite? Or
you may. He's a witness.
Okay. I would like to question him.
Okay, go ahead and ask your question, sir.
Mr. Chancey, when the one dog was out of the fence, approximately how far from the hole were you?
3 feet.
You were 3 feet away. How do you, can you escalate, like how much of a distance it is from the time you seen the dog to the time that the dog attacked you?
The distance from the time I seen it attack me?
Yes. What was the time frame in between?
About 40 seconds or 30 seconds.
Did you at any time turn around and make any kind of hand gestures or jumps or anything at the dog?
Objection, relevance. This is damages, Your Honor.
Yeah, Mr. Hudson. So on this, because you all are in what we call default, meaning you have not actively participated in the case until this time, your questions generally are as to the damages that were suffered, not the actual underlying issue.
Okay, well, Judge, can we, just so we don't have to go through the whole court process, I would just rather, whatever your judgment be, I know it'll be in their favor, and just give me time to just pay it. I just don't want to keep going back and forth about it. I just rather go ahead and get away with it, and whatever you decide on their sides of the case, if whatever it is, I mean, I'll just have to have time to pay it. I would make a monthly endorsement of probably $20, $30 towards it, because that's all I can afford. I don't work for nobody at this time. I don't have a job, period. So whatever I could afford to pay them, that's what I would afford to pay them.
All right, Mr. Samuels.
Just brief summation, Judge, because I wanted to get you the amounts. All these bills are in the record right now, but the ambulance bill is $1,665. The facility bill for Piedmont is $4,914.46. The physician component, $2,244. The radiology component, $24. That's just to review the scans. The special damages, that's the economic loss, $8,847.46. Our ask today in total, economics plus non-economic damages, is $150,000. The basis for that, Your Honor, is, and I would caution the court on trying to tie the damages to the special damages here, because the treatment is, what you can do for a bite is to close the wound and clean it and do shots and make sure there's no infection. And I think we concede too that we're talking about a 3-month period of time where he's having difficulty walking. So it's a relatively short period of time. But I think the majority of the damages come from the visceral nature of being involved in an attack like this. And so having 3 dogs going at your legs, trying to go at your face as you're batting them away. You heard testimony about how he's trying to keep 3 different dogs away at the same time. Multiple bites in one area on the leg. You'll see the photographs again in the record on the worst injury, which I think is the leg. That's a visceral thing for someone to have to go through. And so I think that those non-economic portions are commensurate with that kind of attack, fearing for your life. And thankfully, this really wasn't, it could have been a lot worse, and it wasn't. And so you shouldn't hold it against Mr. Chansey that he was able to get away with minimal treatment. The attack is the attack, regardless of what happened afterward. And so for those reasons, that's why we're asking for a combined total of $150,000 plus court costs.
All right, Ms. Yun?
Yes, Your Honor, I just wanted to be clear. So my client, although they answered the complaint not through an attorney, but through the owner, but they denied in their answer all the allegations that were in the complaint. They also submitted a lease showing that in the lease that no pets were allowed on the property. Since that answer, no discovery were ever sent to the company, and nothing has been done. So I understand that today the hearing is about damages, but we ask that my client not be held liable for for the damages that the plaintiff incurred. They weren't aware of, in the lease, there were no dogs allowed on there. They weren't aware that dogs were on the property. They didn't know that the dangerous, presentity of the dog, that the dog could bite. None of that they were aware of. They didn't know that the dog, slipped through the fence as alleged in the complaint. So none of this was something to their knowledge. They're here today because they received a notice. They just don't want to not attend after receiving a notice. But we ask that they not be liable. I have here my client, if she needs to testify regarding any knowledge, she's here to do it. But I understand that this is a damage hearing, Your Honor.
So we checked, Ms. Yun, and my staff attorney has confirmed that even though the answer was insufficient based on echoes, we did give notice to the corporate defendant at each stage of the proceedings. And so everything that we've done has also been sent to them at the address that we had based on the information that we had. So the same notice that they received to come to court today, all of the other pleadings that were filed and any decisions the court made would have been sent to that same address. And so I get that you're coming in at the last minute, and we don't, as a former defense attorney, civil defense attorney, we don't always get all of the information that is accurate from our clients. But yeah, just your representation that they were not kept aware is incorrect, because the court did continue to send notice to them, even though as a party to the case, even though that they had not actively participated.
Yes, Your Honor.
So, all right. So, Mr. Samuels, the non-economic damages, yeah, I can imagine that the attack must have been pretty terrifying for Mr. Chansey. I don't have a real problem with the amount of the economic damage, the non-economic damages versus the economic damages, because that's why I asked, does he still have scars? You talked about whether he still has a fear of, part of the consideration that we have is fear of injury, the fear that you had regarding the actual attack, and any future fear that's attendant to something that happens to you like that. So I don't have a problem granting the amount of $150,000 in this case, and if plus court costs. So if you go ahead and get me an order, we'll go ahead and do that.
I'll do that, Judge, and I just want to let the court know I also have to file a Rule 15 notice along with that proposed judgment, so I will get that on file at the same time.
Okay, thank you.
All right, thank you, Your Honor. Maybe be excused?
Yeah, Your Honor, I'm sorry, I have one last question.
Yes, ma'am.
So that order, is that against both defendants?
Yes, ma'am.
And but Your Honor, sorry, I know I'm here at the tail end of it, but I didn't see any sort of default in regards to the answer that was filed by my client. And I understand that there was a default against Mr. Hudson for, I guess he didn't participate, so the court has strike his answer, but I didn't see any sort of default against my client.
I will check again, and make sure, but I'm pretty clear that I did.
Your Honor,
grant-
if I could be heard on that,
Yes, sir.
there's a difference between being in default and a default judgment. Today is the default judgment, but they are automatically in default by operation of not opening within the 45-day period. And just so I can, again, make sure, I know it's on, we don't have a court report today, but it's being recorded just in case down the line. If we want to construe my friend on the other side's argument as a motion to open default today, none of the 4 conditions plus paying costs have been met today anyway. So we have the Eccles issue, we have those conditions not being met. So there really isn't, with respect, Judge, discretion to open default at this juncture.
I do not. I lose that after the 45 days with none of those things having been done. So, all right. So we will proceed. I'll get orders out.
Thank you, Your Honor.
All right. You're free to go at this time. It is First Portfolio Ventures versus April Rose.
Yes, Judge Matthew Tilden for First Portfolio Ventures.
April Rose is present.
Okay.
Hey, Your Honor, could I briefly say something, please?
Okay, Mr. Deere.
Sorry to butt in. I have another matter. I've got a deposition set for 1 p.m. It's my fault for not anticipating the timing of both of these two events. Is there any way we could, this matter we're discussing isn't very long. Is there any way we could have a hearing on it at some point after my deposition that might take an hour tops, or reset this hearing on a motion for attorney's fees? I apologize.
So, is the other party here?
Yes, Your Honor, she is.
Yes.
Ms. Baines? No, I'm sorry, Ms. Kaminsky?
Yeah.
Ms.
Yes.
Kaminsky, you want to give your colleague a little grace, or?
Absolutely. If he needs it, no worries. We can reset this, and hopefully Jason and I can maybe get this case resolved before we have to
I'd
come
love
back.
to do that. I'd love to do that.
I'm working as fast as I can, but some of these issues are a little weighty.
Yeah, no, that's totally fine, Judge.
Understood. It's definitely my fault. Lauren,
So
I
we'll
will.
reset you all, and we'll get you a new rule on side. If y'all come up with anything in the interim, just go ahead and get us a consent order or whatever kind of order we need.
Okay. Thank you, Your Honor. Thank you. Ms.
Thank you.
Kaminsky.
For your patience. Thank you, Ms. Kaminsky, for being collegial.
For sure.
All right.
Thanks.
So Ms. Rose is present. Ms. Rose, I'm sorry. I saw your chats, but I couldn't really respond until I could get both sides on. So Mr. Tilden, she just kept saying, I'm here, I'm present. So I get that. So this complaint was filed. Ms. Rose was served notoriously. This is a debt with respect to credit cards. Ms. Rose has denied owing the debt. And Mr. Tilden, go ahead and present on behalf of First Portfolio.
Yes, Judge. So the motion for summary judgment was filed as a result of defendant failing to deny any of plaintiff's requests for admission of facts. I don't believe we received a response from defendant. So our theory of recovery is that all of the matters that were sent to defendant are essentially admitted by law. And just to keep things brief, Judge, those material facts to which there is no genuine issue includes the fact that $1,147.22 was the amount that the balance when this credit card debt was charged off. That's what we're seeking in the complaint. And we are also seeking court costs of $269. A business records affidavit was filed in addition to all the 902 documents. And we do have a proposed summary judgment order for your consideration that was filed as well.
Okay. So Ms. Rose, you filed a response saying that you don't owe the debt, but what Mr. Tilden is basing the request for a judgment on and for is because they sent what we call requests for admissions. So there's pretty much statements that they will send to you. You're supposed to read the statement, and then you're supposed to respond to the statement, either denying or admitting. And if you don't deny or admit these statements, they are deemed true based on the statute. So did you receive the request for admissions?
I received something asking me to show proof that my identity was stolen and credit cards were attained in my name. And I have been displaced like 10 times since all of this has began. And I didn't have what they were asking me. I didn't have police reports because I don't have them. So I didn't know what else to do. And I wasn't working. So I couldn't get a lawyer to tell them, I can't give you what you want. I've already came to court. I told them of the identity theft. I don't know how to show proof of identity theft because my identity was stolen.
Did you go back to the police and ask for additional copies of what you had received initially?
I had no idea that was an option.
Why not? You got them the first time.
It was, I can't even tell you the years that this happened. All I know is I've been answering and responding to people telling me I have a debt, and I'm like, I didn't do that. I still got one with Navy Federal that I'm fighting. It's a lot of people with my name, and the more I keep saying I didn't do this, I show proof. I went through the process of disputing it off my credit. It's no longer on my credit because they deemed, once the first creditor deemed me not responsible, and I showed proof years ago, like 6 years ago, everything else was wiped off. I just kept moving. I don't have it. It was over 6 years ago.
I get that, but did you respond in any way to the request for admissions that Mr. Tilden sent on behalf of his client? Did you? Okay, I get that you read them and said, I don't have this stuff, but did you respond and say, I don't have this, but this is what happened?
No, okay. I didn't. I didn't know what to say once I received it. Then I thought since it was dismissed, it was over, and it was one less thing I got to keep proving to someone until I got a summons. I got to go to court. And I said, oh, shoot.
Okay, so this is the exact same thing that Mr. Hudson in a previous case was saying. For some reason, in a civil case, folk think that it gets dismissed. And I don't know, because I never sent any order saying that the case was dismissed. You can't depend on what happens with respect to your credit bureaus, with respect to your bank, with respect to even the charge off. Those are not dismissals with respect to the law. Excuse me. A lot of times what will happen is you are responding to this on two tracks. One is we're calling you, there's a debt, we're sending you letters, there's a debt. To respond in this way, respond to us. But also you're being served with service of process for the summons and complaint for a lawsuit. You have a certain amount of time to respond in a lawsuit. If somebody sends you something and the directions say you must respond within a certain amount of time, which for request for admissions, I believe that is there, then you got to respond. And you can't just ignore it because you don't have the documents that go with it. You got to respond. And when you don't respond, even if you're talking to them on the phone saying, the legal stuff takes precedence, because I've had people time and time again have a default judgment against them and have to pay the money because they thought, because I was talking to them on the other side and I'm talking on the phone with their representatives, that I don't have to focus on the legal. The law takes precedence. And so if they send you something and they're asking for a response and it says you got to respond under oath, you got to respond in a certain amount of days. I get the, I kind of feel you when you're saying that I was, excuse me, displaced. I didn't have access to things. I've been fighting this tooth and nail from this thing and this thing and this thing, and it gets chaotic. I get you. But if you drop the ball legally on any of these things, then the law's not very forgiving when it comes to, I have a hardship or I'm suffering some issues right now, and it's hard for me to keep up with this. And Ms. Rose, as much as I would like to be able to take all of those things into account, because I have to be impartial, I get that you have a hardship, but there is nothing legally that bars me from granting Mr. Tilden's client the motion for summary judgment, because the directions on your request for admission are, you got to answer these, you got to send them back, and you got to respond to each of the questions. And you have admitted on the record that you didn't do that.
Right, because once it was dismissed when I went to court the last time, I thought it was an error, and I'm like,
well, Mr.
why
Tilden,
is this keep
I don't
coming
have that
up?
this case was previously dismissed. Is this a refile?
Yes.
I'm not
It
certain,
was-
Judge. This case
It was
certainly wasn't
dismissed.
dismissed.
Yes, sir. Hold on, I'll get the actual date. Let me go back to my desk. I came to court, I talked to the lawyer of portfolio, and he asked me questions, and I told him at that time, no, I haven't. This is not me. I have not been there. I have not lived there. On the 23rd, no, April 23rd of 24. This was dismissed.
Okay, then a complaint was filed on May 16th of 2024, and you were served notoriously at your most notorious place of abode.
Notoriously means what is?
Meaning that they handed it to an adult person at your home or where they believed you resided on March 14th of 2025.
I didn't receive anything on March of 25.
But you said you received
I got a letter in the mail saying
So-
that they wanted me to show proof of identity theft. And I said, how? How do I
Mr.
show
Tilden, do you have
proof?
the return of service for?
I think I do, Judge, but defendant filed an answer, and it was timely as well.
That's what I have. March 17th of 2025.
March 17th of 2025. And this was after the dismissal of
Al,
in
pull up
April.
the image of the answer and send it to me, please.
Yes, ma'am.
Yeah, so Ms. Rose, it is possible that the case was filed initially, and when you said, hey, I'm having an issue because I have identity theft, that the case was dismissed. But there's also the possibility that the case was refiled, because it says here that it was served and then there was an answer, a pro se answer, meaning that you answered without an attorney to assist you, that denied owing the debt. Now, if you say you weren't served, but then you answered, that means you're putting yourself into the case. And I get that you're fighting a lot of these, but an answer means you're willing to participate in the lawsuit.
I'm not willing to participate. I wanted to go away, but I once it was dismissed, I just put it under the cover. But
Judge, you cut out, but I'm assuming you asked me if I was sending it. I'm working on it. My system runs slower with Zoom open, but I got it in 1 sec.
if I responded and I said I didn't owe the debt, okay.
That's just, I get that, but that's just the beginning of the lawsuit. They file, you respond, and then you guys exchange information to get to the issues or get to trial. Just saying I don't owe the debt because I had identity theft doesn't end the case.
Okay. Okay. Maybe I didn't understand that completely, but I'm here at work now trying to get this resolved. They're chasing me down $4,000. It's off my credit. It's over. It's gone. And I have read that there's a statute of limitation. I didn't sign anything saying that I own this. I didn't take a loan out with them. And if this was over 6 years ago, why are they still bothering me? It's like it won't go away. And I got people, and I kept telling everyone, I didn't do this. And I've shown proof, but I don't have that proof anymore. I've been out of the state and back here, there, and everywhere. I don't have it anymore. I didn't own it. I didn't sign it. It wasn't me. The last lawyer threw it out. Why keep coming back if it's over? I showed proof back then, but I don't have that anymore. And I'm just trying
Ms.
to
Rose,
move forward.
I
Yes,
got you.
ma'am.
I'm looking at your answer. You did answer on March 17th, 2025, and you did in fact say that you were a victim of identity, not admitting the debt. I get that. But
yes, ma'am.
Lawsuit is not, it's a marathon, not a sprint. And just because you respond that, and unfortunately, when people can't afford an attorney or don't seek help, and there are agencies that will be income sensitive or help, but a lot of people don't know about them, unfortunately.
No.
But if you're trying to travel this road by yourself, it is fraught with pitfalls, because if you don't know what lawyers know, that is a problem. So you did file an answer. Once you filed the answer, then that begins the period is called discovery. In discovery, both parties can exchange information, and this would have been the time for you to send them your information saying, hey, this is what happened to me. I had an identity theft. But also when they send you, which is the most common thing they do with pro se litigants, send a request for admissions. And if you don't respond to it timely and under oath, then they will file a motion for summary judgment, which is what we're doing now, saying that you have not responded to the motions, the request for admission, and they are now deemed by operation of law to be true. And I've
even though I did not say I own that debt and it wasn't me. So because I didn't give them documents that I don't have or know
that, not that you didn't give them documents that you don't have, that you didn't respond at all. If you had responded and said, I don't have the documents right now, but this is not true, that's a response. But you didn't respond at all. You said,
so now I have to take a debt that wasn't me. I can't prove that it wasn't me, and I gotta eat it.
Yes, ma'am.
But I'm not admitting to it.
I get that, but your opportunity to do that was waived when you didn't challenge the request for admission. I know it doesn't sound fair. I'm just going to.
It's not. It's not.
It is not fair. And I'm going to tell you, fair went out the window my first day of law school. There's the law and then there's fair, and they are not the same thing a lot of times. You got me? It is a process. And for people who are pro se, it breaks my heart, but I cannot change what the law says because you are having a hardship. And as much as I would want to be able to tell you where you go or what you do or how to do this, I cannot do that because I cannot litigate or advocate on your behalf.
But it's not a hardship that I'm admitting to, although I was in one. I'm telling, and it's on the record that it wasn't me. It was identity theft. I just don't have a way of proving it. And because I couldn't give you proof that I didn't do it, I have to take a judgment against me for something that somebody else don't have a life to get up and just screw people over. I got to take a judgment.
Ms. Rose.
So I'm fucked up. I'm sorry. Oh my God. I'm sorry. I'm so sorry. I didn't mean that. but that's how I feel in my heart. That's how I feel on the inside. They chasing me for $1,000 that someone else ran up that I said wasn't mine. It was dismissed because I showed them when I went to court that that wasn't me. I didn't live at those addresses. And now you're still they coming after me, even after I said to the lawyer that it was dismissed.
Yes, ma'am.
All right. I can't pay what I
No,
don't
I'm
have.
just like.
I'm not, this ain't fair. This isn't fair at all.
The only thing I can tell you, Miss Rose, is all of my decisions are appealable. I mean, whatever decision I make, there's an appellate court that might make a different decision, but I'm going to send you the order. If you wish to contact Mr. Tilden's client and see if y'all can work something out, even to the extent of you proving to them or sending them information about the theft. And I know you say you don't still have it because you've moved a lot, but you can contact the agencies that you originally contacted and ask and see if they have a copy of the information, because they don't, you know, there are law enforcement agencies have retention times where they have to retain records for certain things. And so it is possible that those records still exist. That's all I can tell you. It breaks my heart on these calendars to have to do this, but I just have to be clear that I don't get to favor one side or the other. I only get to follow the law. All right, Mr. Tilden, was there anything else?
Judge, I'd just encourage Miss Rose to reach out to Reagan and Reagan. I've sent her in a direct message through Zoom the telephone number that she can use to do that. I would like to just say, even though we don't, we're not getting into the facts of this case, I believe there was a review on this account, and because there were multiple payments made on this account, the conclusion was made that there was no identity theft, and that's why the case perhaps was refiled and why we decided to proceed with it. So again, I just
was the payments coming from me? When were these payments? So again, when was this take? I don't
want to get into all that.
Ms. Rose,
the court's time.
If you would have this conversation with Mr. Tilden or the client offline, that would be helpful. If something happens and y'all need to come back on the calendar because there's been some new change that would have caused the court to reconsider, that's one thing. But at this time, the court is not inclined to change its mind or its decision. So you all are free to go at this time, but please continue to communicate because there may be some assistance in that. Okay.
Thank you, Judge. May I be excused?
You may.
Thank you.
Okay, thank you.
Thank you.
We are on the record in the matter of the state of Michigan versus Kritzel Zamorsky, 251612. And then 25443.
Good morning, Honor. Neil DeBlois here on behalf of Crystal Zamorsky, who joins us via Zoom from the Lincoln County Jail. Ms. Zamorsky, if you can hear us, please state your name.
Crystal Zamorsky. All right, thank you. Today is the date scheduled for sentencing and your clients to be on the 251612 matter to an amended charge of disorderly conduct. The assault and battery was dismissed by way of resolution between counsel. And then there's also the jail review on 25443, where on June 10th of 2025, Ms. Zamorsky was sentenced to 60 days jail, suspended pending the review. She was ordered to participate in random testing and no contact with the victim in that matter. And then while she was out on that jail review, she picked up the new charges, which is the disorderly conduct on the 1612 matter. The court will also note that Ms. Zamorsky had previously failed to appear for the jail review on October 20th of 2025 and July of 2025. All right, in counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor. I did go through with her. She indicates that the record is accurate without need of adjustments. With respect to the recommendation, I think the recommendation is that she's not a candidate for probation. I take no issue with that. The recommendation is incarceration. It's a misdemeanor offense. She's been incarcerated now apparently since her arrest, which was date in November, I believe.
November 18th, yes.
Yes, well, November 18th. In any event, we're at about approximately 90 days, it appears. I think she's, in a word, done her time served, would be, I think, appropriate under the circumstances. On another consideration, she's quite distressed at the moment. She's the primary caretaker. Her mother's taken a turn, her health has taken a turn. Somehow she felt her mother was supposed to be zooming in today. I had no information about that. But she can, obviously she can explain better. Apparently her mother's health condition is deteriorated, and she will beg the court to release her at this point. So she can attend to that.
Okay, ma'am, and why would you think that your mom would be zooming in today?
I just talked to her because she said she was gonna talk to you. I don't know if she was, maybe she just got confused, but she's really sick with stage 4 lung cancer. And
pause a moment. Tell me why you were speaking to your mom when the court order says you're not to have any contact with your mom.
I didn't know I wasn't supposed to have contact still with her. My mom's sick with cancer, Miss DeSanto.
And your mom is the victim in this matter, Ms. Zamorsky. So I ordered you not to have any contact with your mom. None. Zero. Your mom's continued to be a victim of your behavior. Yet you're violating the court order and having contact with your mom.
I didn't know.
That's not accurate, ma'am. I reiterated the bond conditions and I indicated bonded conditions were to continue. You indicate that your mom's health is deteriorating and she has stage 4 lung cancer, yet your mom is the named victim in these matters. And this is not the first time your mom has been the named victim in a matter that you're the defendant on, is it?
We just got in an argument.
I'm sorry?
We just got in an argument. That's why she was supposed to be on Zoom to talk to you, to let me back home to take care of her, because no one's there to take care of her.
Ma'am, who was the complaining witness in your 2014 matter of malicious destruction of property?
I don't know. I don't remember back then.
All right. What about domestic violence in 2016? Who was the complaining witness in that matter?
I don't know, ma'am. I don't know about I don't remember that far back.
All right. What about 2019? It's a little bit closer in time. Assault with a dangerous weapon, the felonious assault. Who was the complaining witness in that matter?
That was my brother, and I completed that.
The court will note after hearing from counsel, hearing from Ms. Zamorsky, reviewing the report, the recommendation. Is Gloria Zamorsky present? No. The court does not find that there's reasonable grounds to depart from MCL 769.5. The court's going to order on 251612. The court's going to order 90 days jail. I'm just going to see what the actual number of days is, counsel.
I did 86.
Excuse me, ma'am. Thank you. I will count right now.
Who's there?
Credit for 86 days.
You out too? No. Let me grab the mic. Take over.
The court will suspend fines and costs as it relates to the jail review on 25443. The court's going to order you to serve 30 of those days. You're going to serve 30 of those days, and then we'll close that matter out, and we'll waive the fines and costs.
I have to do 30 more days?
Well, technically 34, ma'am. You have 86 days credit on the 90 days, and then 30 days on the jail review.
I have to do another month in here?
Yes, ma'am. That's on your 25443 matter.
Wow. Wow. That's insane.
Well, ma'am, that's on the jail review that this court had previously suspended jail.
I've been in here 3.5 months. You could have given me the consideration and gave me time served.
I did, ma'am, on your first one. The other one, you're serving 30 of the 60 days. I didn't
So
order
when
an
do I
additional
get
60
released from
days.
here? So when's the
Excuse
next
me?
court date? When's the next court date?
You don't have another court date. I just held the sentencing and I've done the jail review. You were looking at 60 days on the jail review, and I reduced it to 30 days, not 60 days.
So I just got to do 30 more days in here.
34, yes. 4 on the other matter. You have 4 days left on that matter. Yeah.
I got 3 over this way now.
Have a good day.
Courthouse case, People versus Michael DeWitt.
Morning again, Your Honor. Dan Garrett on behalf of Michael DeWitt. Stepping forward, Michael.
Michael DeWitt. Thank you.
Your Honor, we're here for sentencing. I understand there may be a victim statement today.
All right, very good. Where does he have a seat there?
Your Honor, the victim in this case is Joshua Wade.
All right.
Hello, Your Honor. My name is Joshua Wade. I'm the victim in the case. Your Honor, I provide the court a written statement, but I wanted to provide a brief verbal statement in summary. It is my understanding that Mr. DeWitt has shown true remorse over this incident and is prepared to make full restitution. I'm also under the understanding that he has no prior criminal record. I support the terms of the plea agreement as I understand them, namely a period of probation, anger management, and with a delayed and restitution with a delayed sentence so that he does not end up with a permanent criminal record. Mr. DeWitt's actions impacted me in several ways that I mentioned in my written statement. However, I want to call attention to the impact on both myself and Mr. DeWitt that did not occur, but could easily have. In Michigan, more than 1 in 10 adults holds a concealed pistol license. We are ordinary citizens who go about our daily business much the same as everyone. We don't look any different, and yet we carry with us the means to effectively defend ourselves from grave danger. On the day of Mr. DeWitt's crime, I was carrying a SIG P226 9mm with 15 rounds and 1 in the chamber. As he approached my vehicle and confronted me, my primary thought was to ignore his provocations so that I would not be placed in a situation where I may need to defend myself with force. When I parked and Mr. DeWitt remained in the area, I went inside rather than risk a physical altercation that could have had tragic results. As you know, Your Honor, Michigan has no duty to retreat. However, I chose to retreat from the area while Mr. DeWitt maliciously damaged my vehicle rather than remain and potentially become involved in a situation that could have been tragic for Mr. DeWitt and for all those who love him. I say this not to intimidate or threaten Mr. DeWitt, but rather because it is my sincere hope that he learns from this event the importance of moderating his temper. Thank you, Your Honor. May I proceed, Your Honor?
Yes,
Your Honor, Mr. DeWitt and I have reviewed all the reports. They are accurate. I believe the recommendation is appropriate. He's glad to see that the prosecutor's deferred has been recommended. He's asking Your Honor to follow that. Just a background, Mr. DeWitt is 59, soon to be 60 years old, never been in trouble a day of his life.
he was undergoing some pretty serious health concerns at the time and just lost his temper. We've all had our bad moments. He's very remorseful for his conduct. He's ready to pay all restitution and fines this morning.
Anything you want to tell the court before I impose sentence?
To assure the court that I'm remorseful for my actions. I apologize, and it won't happen again.
Sentence of the court, I'm going to place you on 6 months prosecutor deferred sentence. You are to pay $555 fines and court costs, $180 probation oversight fees, $868 restitution to Joshua Wade payable through the court. You can pay that all today.
Yes, sir.
All right. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management program as directed by probation. You're to have no contact with Joshua Wade directly or indirectly. There is to be no assault or threatening or intimidating behavior on your part. I'll set your review hearing that's to be held August 12, 2026, 9 a.m. I will order 365 days in jail that is suspended. All right.
Does restitution have to be paid in any certain amount of way? I never remember that. Cash
It
only?
has to be cash.
Okay, sounds good. You can come back and do that.
I have it.
You have cash. Sounds good, Your Honor.
I think Ms. Polero probably would have told it.
That's probably true. Sounds good, Your Honor.
Thank you, sir.
Nothing there. Nothing was about Jocelyn. Chat. Just so the viewers know, the chat was obsessed with what was going on with Jocelyn smirking in the last case. But we're not going to find out anything about Jocelyn's case because that was more about the guy who almost got shot. I thought that was a pretty powerful story. And I had to have a little bit of Simpson for the end of the evening. What can I say? I love me some Judge Simpson. Stay tuned, ladies and gentlemen. Do not go anywhere. Do not change the channel unless you're going down to the description. And right now, you're following that link that Rhonda just put in chat, actually. You don't have to go to the description. You can just use the one that Rhonda put in chat right there. That would be great too. And go watch Hutch's amazing case with Judge Stevens with a pro se defendant who has a lot to say. A lot to say. So go on. Yeah. Let's go. We're done here. I'm not gonna hold you back. We're done. I really appreciate you. I've got a lot more stuff. We're gonna watch it tomorrow. Come on by, 8 p.m. Central, 9 p.m. Eastern. Wait, did I get that right? Yeah, I got that right. And yeah, there will be a lot more, because court cases happen every day, except for on President's Day, and we'll probably have something special happening then. And don't forget the weekend. I've already got stuff set back for the weekend. I don't even want to get into it right now because we got Hutch. We got Hutch coming up. That's what's happening. That's what's happening. There is no Ferris Bueller Day Off reference coming up tonight because it's all about the Hutchster and the sovereign citizen encounters. Yeah. Thank you guys for showing up. I do want to give a very special shout out and thank you to Heidi Marie for their support. I'm not sure if it's a he or a her, but I'm pretty sure it's a her, maybe, possibly. Thank you so much, everybody. Thank you to the lurkers. Thank you, Mom. Thank you, Rhonda. I just don't know how to say thank you enough for it to be actually enough. Go, get out of here. Hutch is waiting. He's got a good case play. You don't need to watch me. I'm just rambling now. I'm vamping. It's silly. I should be dancing. opened a second tab and have them both playing. Now that's big brain moves right there, ladies and gentlemen. I conned you all out. I did do a Ferris Bueller Day Off outro. Get out of here. There's nothing else to watch. Get